Ladies and gentlemen, welcome back to the channel, and say hello to one of my favorite LawTube accounts. Zac Morgan is back by popular demand.
Thank you. Thanks for having me back.
How are you doing, Zac?
I'm good, man. We're making it.
Yeah.
Every day I get up, I consider that a win at this point in my life. So
Exactly. I mean, Aaron Smith-Levin is currently live on Growing Up in Scientology with Jenna Miscavige. So we were going to push it back, but there's a few scheduling difficulties. So we're just going to crack on with it anyway. And there's going to be people that can catch this on the replay. So yeah, for those of you watching live, thank you. Jump in the chat and ask us questions and so on. And for those of you on the replay, leave them in the comments and we'll get back to you. But today we're going to be looking at the staff contracts. Zac obviously is a trained and verified and what's the word, accredited lawyer. So I thought who better to come on and have a look at these things. So to give a little bit of background before we bring up the documents, there are two types of staff member in Scientology. There's a Sea Org member, Sea Organization, and then there's the Class 5 staff member. So Class 5 is like the city level churches. That's where anyone would join Scientology. So that's London, New York, Tampa, all these sorts of places. And then the Sea Organization run the upper level management at St. Hill and all of the organizations over in Los Angeles and so on. And the Sea Org are the ones that sign a $1 billion year contract. I signed my contract but never arrived in the Sea Org. But essentially, every staff member at a Class 5 org will sign a 2.5 or a 5-year contract to work for the church. And it's not just one contract, it is a small stack of contracts. Yeah. So I thought we could go over some of those and pick your brains on it, Zac. Do you have any comments before we delve into it?
Sort of the preface that I give, right? We're talking about general principles of American law, and I know that you're British, but you were working for an organization that's organized under the laws of Australia. And so, the perspective I'm bringing is, because there's going to be similar language to this for all the U.S. based orgs as well. And so the approach I'm bringing is the U.S., the way the courts would generally interpret this and the way the law generally works in the U.S. And although there's probably some commonality because ultimately we all derive from British common law, there's going to be some unique aspects of this subject to each nation. But generally speaking, it should be fairly close.
Yeah, absolutely. Especially if you look at it from the fact that these contracts are ones I got from someone who sent them in from an American org. They are exactly the same as the ones that I signed in London. So they're universal contract and universal agreements. And there are a few things that just don't apply in UK law. For example, priest penitent privilege is not a thing in British law. So there are references to that here in these documents, but that just simply doesn't hold true in the UK. There's not a law that allows for that sort of thing. So these contracts are universal. It doesn't matter what organization, what city, what country you join staff on. These are the contracts you will have to sign. So there's a whole debate about whether they would be enforceable in each country. But I thought it'd be interesting to ask your thoughts, sure, from an American point of view, because it is an American organization. There is a super chat in the live chat. So Christian B, Alex, loving what you're focusing on with the Scientology bullshit. You and Zac together talking about this is amazing. Dream team. Nice.
Thank you, Christian.
Thank you, Christian.
So, Christian, I think, is a big supporter of the SPTV Nation. He's in my chat quite a bit. I've seen him in Aaron's. He was in Aaron's yesterday when Aaron and I did, or was it yesterday or whatever day Aaron and I did one. And then he's here today. So, normally Christian's going to bed about the time I'm going live, but we did this a lot earlier in the day. So I think he was able to catch us.
Amazing. Also, a couple of people are saying in the chat that your mic is still a little bit low. Are you able to up the volume?
I can push it a little bit. All right, let's try that. There we go. Try that, folks.
Is that a bit better? Let us know in the chat. Say a few words.
Sure. So I recently got an equipment upgrade, so we're just trying to fine tune the audio perspective of it. So hopefully that works.
It's good. It's still a little bit quiet, but I think it's better than it was before.
Sure.
Alrighty, let's pull these up. So there's quite a lot of documents that you have to sign. One of them is a life history. I didn't send that over to Zac beforehand. Life history is where you basically have to fill out like your past history of everything you've ever done, who your family are, who your employers were, what your family does for work, your sexual partners, all this sort of stuff. That's a whole big form you fill out, and then you get given these documents. So the first one is application, declaration, and general release. Declaration of religious commitment, an application for membership in a Scientology religious order, and for active participation on church staff. And it fills out, you fill it out here. So you put your name in here and your address, and then you fill out the blank here, as you can see, a member of the Church of Scientology of, and then you put in London or whatever city you're in. What are your thoughts on this, Zac?
So the first part of this, everything above the information block that's going to be super standard, we refer to that as boilerplate. And it's a contract has to clearly identify the parties to the contract. Most contracts involve two parties, but you could have a contract that involves three or four or five. And so that first part is just identifying who, in this case, Alex would have been, or Aaron, or whoever the staff member is. It's identifying them as the party to the contract. And you, by writing that in, by leaving that blank and having somebody write it in by pen, there's this misconception that a contract has to be, typed up or something. That's not inherently true. There are some contracts that do have to be written, where a verbal contract wouldn't count, but under the statute of frauds. But that's not really what we're focused on here. The top part of this is super boilerplate, and it that way they don't have to worry about what we call Scrivener's errors. The data entry clerk punches the name in wrong or gets the wrong address or something. You just let the person who's applying fill this out, just like you would a job application, essentially.
You know what I find particularly interesting is the first clause is, if a minor, I've obtained consent from my parents or guardian to do this. Now that stands out to me as like any child can say, yeah, I got my parent to sign this, not a problem. Like the parent or guardian doesn't actually have to sign anything. I was a minor when I signed my first Scientology staff contract, and my mum never had to sign anything. I just had to say, yes, I've got their permission.
So there's, on one of these documents, on the bottom of the document, there's a line that says parent if applicant is a minor. So one of these documents does contain the line for a parent of the age of majority. But to your point, if a minor were to sign a contract, a minor signature on a contract does not automatically make the contract voided. It makes it what we call voidable. And essentially, in most jurisdictions in the United States, if a minor signs a contract, they have until their 19th birthday to change their mind and undo everything. And this is why, even if you have, a great credit score or something, lenders, banks, car companies, whatever, make it. If a minor is taking out a loan or something, it has to be co-signed by a person, even if they have a fantastic credit score, because there's nothing to stop me from driving that car off the lot, driving it for 2.5 years, and then turning it back in right before my 19th birthday and saying, you can have it back. I want all my money back. I want to undo the contract. And so you have a co-signer who is then legally responsible. So just by virtue of a minor signing a contract doesn't actually make the contract voided or illegal. It makes it voidable, but only at the discretion of the minor until the minor turns 19.
Interesting. Okay. All right. That's a good point. I mean, is there anything that you want to hone in or talk about specifically, and I can go and find it in the contracts, or do you want to just kind of bosh through it bit by bit?
So it's if I were sitting down doing this with a client, we would start at the top and work our way through. Looking at things that we find interesting, asking questions about things we don't understand, and then if I have an example or whatever, that's generally how I would sit down and review a contract with the client anyway.
Okay, fine. So the next bit goes on, you have to declare, for example, you haven't had any drugs before, or psychosis, or, mental health history. I've never sued the church, or I've never left the church by an unauthorized departure known as a blow. This is stuff that I'm not particularly surprised about. Is there anything that stands out there for you, Zac?
Not necessarily. The I am not an active drug pusher is interesting language. I think that probably dates back to the LRH era. This has, of course, been updated over the years by attorneys, but that dates back. That's probably no, that's not a term we commonly use. It was common back in the 70s and into the early 80s, especially during the HIV/AIDS epidemic. A drug pusher, that's not generally. Today, if somebody is described as a drug pusher, that's going to be, for example, a drug wholesaler or somebody higher than a street-level dealer. In this context, they're actually, if you look at number 4 above it, it implies that it's referring to drug use and not just the transportation or wholesale production and sale of narcotics.
Sure. Okay, fair enough. And I think they're quite reasonable things to ask in any sort of employment contract, right? It's not out of the
No,
realms of possibility to want someone to declare that they don't use drugs before starting a job, right?
right. Yeah. Now, generally speaking, number three. So number one, we've talked about that. Number two, convicted of a commission. So, yeah, a lot of job applications refer to your criminal history. Number three is borderline. Um, that seeks personal protected information unless you can show that the job requires no history of mental health condition, which you can't prove in this case. That theoretically that could be stricken if challenged. Hey, number three isn't a valid provision. Well, the court would just throw it out and leave 1 through 7 minus 3. So number three is probably invalid, but not enough so to throw the whole contract out on its face.
What would you have to? 'Cause I'm going to pull us back up here actually. My understanding of contract law is just having one clause that isn't valid or whatever. That doesn't invalidate the whole contract, right?
Correct.
Is there like a limit if 50% of the clauses are invalid, then the whole thing gets thrown out, or
Not not
how does that work?
necessarily. So what you're referring to is called the savings provision, or the rebirth or reincarnation clause. Most commonly, it's called the savings provision, savings clause. If one or more parts of this contract are deemed, unenforceable or void, the rest of the contract is valid. We just get rid of the stuff that's not valid. So basically, you don't have to go back and renegotiate the materiality of the contract. But the bigger issue is, at least from the legal perspective, is a contract will continue to be enforceable until it can't, right? What I mean by that is if under the common law, a contract had to have basically identical number of terms, they all had to match. And so the Uniform Commercial Code, which doesn't apply here, but it has a really good definition, there has to be a sufficient number of sufficiently definite terms. If there's not enough in the contract left for a court to be able to piece it together, you don't have a contract. Courts aren't in the business of guessing. They're going to read the contract and apply the contract based on their interpretation of the intent of the parties. So there's no hard and fast limit of how much contract you do or don't have to have. Some contracts are so specific you have to have 90%. Some contracts are so broad you could have 10% of the contract remaining and it still be enforceable. So as long as you have a sufficient number of sufficiently definite terms, and that's sort of a moving target to be determined by the court, but as long as you have a sufficient number of sufficiently definite terms, the contract will continue to be enforceable.
Do you think that's why there are so many? I mean, each of these contracts do have different things that they're focusing on, but a lot of the clauses and terms are repeated in the majority of these documents. Do you think that's why they've done that? So that if one contract gets thrown out, they still have covered their backs by having the same clause a couple of times?
Maybe part of it's stylistic as well. Some lawyers repeat themselves. Some attorneys repeat themselves over and over and over again in contracts, and some just say, like, you get to say, part 2, part Roman numeral 2, part Roman numeral 3, and number 1 of Roman numeral 2 says all prior references in this contract are incorporated as a fully set forth herein, which means we're going to include parts, all of part 1. Also, we're just not going to say it again. And
Right.
so it's a stylistic thing more than anything, really.
Okay, fair enough. That makes sense. Okay, cool. So I've never sued the church or any Scientology organization, or made any complaint to a government authority with respect to the church, any member of the church, or any Scientology organization. Thoughts on that one?
That's fair. If somebody has a history of suing a business, if I have a history of suing Walmart, Walmart has a reasonable, they can be I can reasonably expect them to do a check to make sure that I haven't made a pattern of suing them. Now,
Do you think it's
it can
fair?
also be contextual, but
I
it's
was going
pretty
to, yeah.
common.
Do you think it's fair, even though they've included any member of the church as well as themselves? Can they put
So
a clause in there that
yeah, they can. It's overly broad, but
Mm,
and it's maybe unnecessarily broad, but a business, which is exactly what the church is. It's nonprofit business in the States, but it's a business can take reasonable means to protect itself from litigation, and that's one of them, right? Like, hey, you may not have beef with the church, but you may have beef with somebody who works at the church, and we don't want to be the playground where the bullies are throwing punches. And so
sure.
if you're sideways with somebody at the church, then we certainly don't want you. We don't want you here creating problems for us.
Okay, all right, fair enough. Number 7 is I'm not a blown staff member or blown SEAL member. Blowing just means leaving, making unauthorized departure. That's like me signing up to join staff, and after a year, just not showing up to work anymore, and not telling them why, and not finishing my contract. That's what Scientology refers to as blowing. So, I'm not a blown staff member or SEAL member. I think it just explores that a little bit further here. You have never
Yeah.
departed a staff position without.
Yeah, and this is why I think it was written by an attorney, because here we have a term that's not defined: blown staff, blown Sea Org, and then it says that's an attorney phrase, that is, comma, or for example, or meaning, I have never, and then it defines it. So that's why I think this was developed. The first iteration, at least, of this, at least, was written by an attorney somewhere, because that is written like an attorney would write it.
Sure. And it carries on. I have in the past blown, either I haven't blown or I have, but have since recanted and been given forgiveness and accepted back into the church after having made proper restitution. So that's the other alternative option they give you there, right?
Right.
I am not related or connected to any intelligence agency, either by past history or immediate familial connection. Now, I have a question on this. If I was like a spy for the CIA or MI5 or something, I wouldn't be allowed to disclose that. So I would have to lie. Where would that leave someone in signing this contract? Because they would have to, because of official secrets and all this, they would have to say, no, I'm not connected.
Well, it would make the contract voidable. It wouldn't automatically void the contract, but it would give the church the choice, if they chose to void the contract, because there was a materially untrue statement made in the application. Now, this isn't perjury. You can lie on this all you want to. You're not going to go to prison. The worst case scenario is the contract gets undone and nobody's bound to it. So this is different than signing a government form or lying under oath or one of those things that is perjury. But the concept is similar, but the execution a little different.
Okay, fair. Number 9, I do not have a parent or guardian who is antagonistic of Scientology or any organization devoted to Scientology applied religious philosophy. I mean, that doesn't sound overly mad to me. Number 10, I'm not seeking a staff position to obtain material for dissemination to the public via press, radio, television, motion picture, or any other media. I do not seek to attain any data for any other organization or to disrupt the church. This is basically asking, are you here to cause trouble, right?
Well, that, and it's also detailing that, by virtue of joining this organization and being in service to the greater organization, the greater mission of the church, you will likely be have access to and be exposed to things that are trade secret, proprietary, or otherwise unique. And you're basically giving a statement that, hey, if I get accepted and I'm able to join, I do not intend to use my access to material in a way that would be unbecoming to the church, is essentially what they're doing. They're just trying to protect their intellectual property.
Sure. Okay. I do not have personal debts of magnitude such that efforts to satisfy them would immediately disrupt or cause me to pull back from my commitment to the church. This is just asking, are you a risk to us, right? Are you going to create a problem for us financially?
Yeah, if you owe so many people money that when you come work for us for $50 a week, if you're lucky, and you can't pay your debt, you're going to have to quit and go back to work in the regular workspace to pay your mortgage and your car.
Sure. And number 12, I do not have any mental institutional history. Again, this is was already covered earlier on, right? I have no institutional history of psychosis.
It was, and it also gets into information that's protected by HIPAA. So unless it's uniquely specific to the position you're applying for, and it's not, this is a uniform contract. So, for example, if I'm working in the federal government and I'm trying to actually, get a secret or top secret security or sensitive security clearance, that's a reasonable inquiry that they can ask. But if this is just to be a phone answer, or sit at a desk, or to, count the carpet threads, or to paint walls, this is an inappropriate and really, by U.S. law, an unlawful question or an unlawful request.
And what does that mean for the church in terms of the fact that they are supplying these contracts and putting them out? Is that a civil or a criminal thing?
No, it would be civil, and the worst case scenario would be if you were to ever be fired, for example, because you said no, you don't have a mental health history, and it turns out you do. and the church finds out and they fire you because of that, you could say that, hey, my mental health history doesn't apply to this job, and the fact that you requested it is unlawful. When I say unlawful, it means it just violates some law, whether it's a criminal law or a civil law. In this case, it would just simply be civil, and so you could sue the church for reinstatement, for wrongful termination, unlawful termination, and then if you win your lawsuit, you get your job back. That's all that means.
Fascinating. Okay. I have no prior service in high security section of government or armed forces. I mean, that's similar to the, I'm not a spy question, right?
Right. Essentially, I mean, the church sort of views itself as battling everybody in the world, and they want to make sure you haven't at any point in your life or prior lives been aligned with the bad guys from their perspective.
Sure. Okay. My spouse has no objection as to working for the church.
So that's generally just like with the HIPAA question. The HIPAA is the Health Information Portability, it's the Health Insurance Portability and Privacy Protection Act, or something along those lines. It's basically the medical privacy laws of the U.S. This would be similar. If you're using, I view these like an interview question, and so they're not allowed to ask me in an interview if I'm married. They're not allowed to ask me if I have children. There's just certain questions by law they're not allowed to ask me. This would be the same thing. If I'm fired because they find out my wife is mad that I work there, then I can sue them and be reinstated if I win to get my job back because I was unlawfully terminated. That's all that says.
So you said something there that's interesting. They're not allowed to ask the questions that are personal, like, are you married and so on. Now, on top of these contracts that we're looking at here, you have to, I mentioned earlier, you have to fill out what's called a life history, and you have to give them basically every piece of information there is to know about you. Questions like, what does your brother do for work? Where does he live? What do your parents do? Like literally everything, right down to your sexual partners and things like this. You have to do one of these in order to join staff. They won't let you join staff without filling this form out. Is that in itself something that they shouldn't do, that they shouldn't be allowed to do, or they're breaking some sort of law?
Yeah, it would be an unlawful or discriminatory hiring practice, but somebody would have to challenge them on it. Somebody would have to say this job is worth taking them to the mat, taking them to task about. But that's like for regular jobs that aren't, cult-based employment. For regular jobs,
Cult-based employment. I like that.
At a normal job, once you accept it, you receive a job offer. Once you accept the job offer, as part of your onboarding paperwork, they're going to ask you, do you have kids or a spouse you want to put on your health insurance? Because of course we have privatized health insurance. We don't have the NIH here in the States, or the NHS. Sorry, National Health Service.
Yeah.
We do have the NIH, National Institute of Health. We don't have the NHS. So it'll ask you those kind of questions, and then it'll say, who's your emergency contact and what is their relation to you? Is it your child? Is you spouse, child, parent, whatever? At that point, those questions are perfectly valid because you have already gained employment. They cannot seek that information in determining whether or not to offer you employment. There's a difference.
So it depends on whether they get you to do your life history before signing these contracts or after signing the contracts, right?
Exactly.
And where does it stand with the idea of being a religious volunteer? Because in UK law, for example, you are not, so the church pitch it as you're not an employee, you're a religious volunteer, and that's how they get around not paying you minimum wage. However, technically I was employed by the church. I got a pay slip, for my £20 a week or whatever it was, and I got taxed on it and paid my national insurance, which is my social security. So on paper, I was employed by the church, but because I was a religious volunteer, they got around a lot of the labor laws. But there is also a clause that's fairly new to British law that, in a nutshell, says even if you are a volunteer or you're a freelancer and a contractor, if you are, for all intents and purposes, doing the same work as someone who would be an employee, you are under law considered an employee and therefore entitled to the same rights an employee would. How does that work with the US?
So in the States, it's similar. So the religious volunteers, even if you're a volunteer, if I'm working inside the four corners of the church that I attend on Sundays, sweeping floors or picking up tables, and I'm not even being compensated. I'm just doing that as part of my ministry to the church, and I become injured, I'm still covered by workers' compensation liability insurance and some of those sorts of things. But the U.S. has a very it's a little bit complicated string of case law that establishes the agent versus the contractor. Agent acting on behalf of, contractor acting on behalf of yourself. And so, for the most common examples here in the States are companies like UPS and FedEx. Okay, so it's a parcel delivery service here
Yes.
in the
Yeah.
state. Okay,
Yeah.
okay. And so, where I work at the airport, we get packages all the time from our vendors who are supplying us parts for parts inventory and things. And so the FedEx truck rolls up, and the FedEx worker gets off the truck, and they have a FedEx uniform on. It says FedEx. They have the purple and the blue and the white,
Mm.
whatever color. But on the front of their truck, it says, FedEx Express powered by Joe Blow Transport LLC, for
Sure.
example. In that case, they're a contractor, kind of. The law's actually a little bit gray here because if I work for FedEx, I'm clearly a FedEx employee. But if I'm a contractor for FedEx, FedEx is only allowed to have so much control over me,
Mm-hmm.
to the point that the FedEx contractor agreements used to say, like, you have to have a truck of this size, and you have to have this type of shelving, and it has to be organized in this manner, and you're not allowed to run the air conditioning, and you're not allowed to idle the truck, and this and that and the other. And you have to wear our uniforms, and you have to buy this particular scanner because it's the only thing that interfaces with our proprietary software, et cetera, et cetera. So at one point, the court said, you are too closely related to FedEx. You are no longer a contractor. You are FedEx.
Mm-hmm.
You can put Joe Blow Transport on the side of the van all you want to, but at the end of the day, you're a FedEx employee. And so there's sort of this moving target. FedEx wants their branding out. They want people to know that the guy showing up is delivering on behalf of FedEx. But if he gets involved in a car wreck on the highway headed home, FedEx says, "Oh no, he's a contractor. He doesn't work for us. He works for himself. He has a contract with us." Well, you can't have it both ways. You can't use the branding and the marketing and the quality control, but also when something happens and there's liability involved, run for the mountains. You can't do both. You can't have it both ways.
So where does that come into terms, like when we're looking at cult-based employment, which I love that term. I'm going to use that a lot now. Cult-based employment. So they will try and say, no, they're a religious volunteer, and therefore we don't have to pay them minimum wage, and we don't have to give them all of the rights and things like that you would get as an employee. Would it be, when you work for the church, you're given a job title, you're quite often given an office, you're expected to work 9 to 5, Monday to Friday, or whatever the work hours are.
Mm-hmm.
It's not like you're going in to help, run a Sunday raffle at your local church, that
Right.
sort of volunteering. It is a very much a full-time job and a career. How would that affect the church's or the person's rights when it comes to being seen as an employee rather for minimum wage and things like that?
That's a good question. It hasn't actually been decided here in the States.
Okay.
What's unique about here versus the UK is the UK has a single judicial system. Well, you really have two. You have the Court of Chancery, which is traditionally, you have the Court of Chancery, and then you have the King's Court or the Queen's Court, whoever the monarch is. And the Court of the Court of the Chancery was basically what we would call issues in equity, and it was decided by the priests of the church. And then you had issues involving money, or what we would call legal issues sounding in law, was seeking legal remedies, and that would go before the King's Bench or the Queen's Bench. So in the United States, those are together, but we also have layers. We have federal law, and then if you can't get into federal law, or federal law doesn't address it, then we have state law. If that doesn't address it, you have county and municipal law. So we've got sort of these various layers, and that's sort of unique to the United States, in that the UK really has a single judicial avenue. And there's various courthouses and various judges, Lord Judge or whoever, sitting at various courthouses across the British countryside. But they're all at a single level. Here we have multiple levels of court, and we have different courts sitting in different, like the same judge in the morning could be sitting in equity and landlord-tenant law, but could be sitting in law, on a car wreck dispute. And then
Right.
the afternoon could also be sitting in law on a felony arraignment docket. So, judges here can often sit from day to day, hour to hour, case by case, both in equity and in law, on the same docket call even. So it's a little bit unique here, to where in the UK, you guys tend to split those. You have courts of equity and you have courts of law, and the courts of equity are generally handled through the chancery.
Magistrates.
Through the magistrate system, and then the courts of law and the King's Bench handles, and the British Supreme Court ultimately.
Yeah, so it hasn't been tried in court yet in the US about whether something like this would be considered an employee and therefore entitled to employment rights. Is that what you're saying?
Essentially, and part of the reason for that is because these arbitration clauses. that the church has so far been successful on. Although there's some
Yeah.
legitimate challenges out there that are going to challenge that, and I think could result in a different outcome. You know, various courts may have taken it up and decided differently. The template they tend to refer back to is like the Roman Catholic Church with the monks and the friars, and then the Buddhist faith with the Buddhist monks. Right. So those sort of the templates they tend to refer to, because the monks and the friars, they don't receive compensation,
Mm.
but in exchange, well, they don't receive monetary compensation for work performed, but they're given a place to live. They're given clothes to wear. They're given food to eat, and in exchange, they provide services for whatever their religious order is. You know, whether that's
I
working in the
think
kitchen
that's
or
what
working in the garden or whatever.
Yeah, that's where it's interesting when we look at this from the perspective of a class 5 staff member. Because, yes, in this organization, you're like a monk or a nun, you've dedicated your whole life to Scientology, they give you accommodation and so on in return. But as a class 5 staff member, working at a city level org, you don't get things like accommodation and food provided for you. You are expected to hold employment elsewhere. It's called moonlighting, in order to subsidize or cover your finances so that you can volunteer a full-time job for the church. The only thing you get in return is a weekly stipend, which depends on how much money the org makes the previous week, and they give you free servicing to say thank you. That's it. They don't give you food, accommodation, anything like that. Interesting. Should we carry on looking at this? So we've got, I'm not currently on drugs. We've looked at that already before. Number 16, I've seen the film Orientation. I'm informed and aware that Scientology is a religion, its teachings are religious, and it claims are religious in nature. I further understand that if I desire to participate in Scientology services, I do so being fully aware that these are religious services and that I'm participating in them under the ecclesiastical principles of the Scientology religion. What's your take on this, Zac?
It's just putting the person signing it on notice that they're seeking or attempting to secure employment or other consideration in a religious capacity, and so they can't come back later. So Scientology is not a religion; it's just, you know, it's Dianetics, the modern approach to mental health or whatever, right? So no, we're telling you this is a religion. It's also an attempt to, you know, so one of the rules is if you claim to be a religion, you claim to be a corporation, you claim to be whatever, you have to walk the talk. You have to walk the walk, and if you talk the talk, and in this case, they're talking the talk, and then they're going to say then by working for us, you're going to walk the walk. And so if they're ever challenged, they say we told them from day one, we're a religious organization, and right, it's the whole put them on notice thing.
But what happens if, I'm quite, entitled to change my beliefs. And at the time of signing this, yes, I could agree that Scientology is a religion, its teachings are religious and so on. But tomorrow I might wake up and think, actually, I don't think it's a religion anymore. What impact does that have on the contract and its enforceability?
Oh, not necessarily, really nothing. You know, I know people who have worked in churches who aren't Christian. I know there are people who have worked in denominations who do not believe the teachings of the denomination, but it was a job, it was a paycheck, it was a way to feed their family. Just because one isn't a believer doesn't mean that one isn't otherwise qualified, which is a little bit counterintuitive, but you get the idea.
So this clause doesn't lock someone into, because they're saying I am aware and agree basically that it's a religion. It doesn't force you to have to subscribe to that doctrine for eternity, right?
No.
Okay.
You know, as I sign it today, it's a religion. But when I find out about body thetans and Xenu, I'm out of here. I'm out like a fat kid in dodgeball. So I don't want any part of this.
Okay. 17 here. This is a little bit specific about a policy letter. It's basically just saying that I've read this policy directive, which is all about statements of staff members. Essentially, what it says is that as a staff member, if I say something about Scientology, like Scientology will help you cure this illness, that is a statement by the individual and not by the church. You as a staff member, and anything you ever say and anything any staff member has ever said is not the view of the church, it's your personal view. That's essentially what that directive says.
Yeah, if challenged, there's a strong likelihood that directive could be viewed with some consternation by the courts.
Okay.
there's a point at which if your job title is spokesperson, if your job title is press secretary, if your job title is director of communications, by virtue of your job title, you're speaking on behalf of something. Whether you're speaking on behalf of David Miscavige or of the organization or whatever, there is a point at which, when the presidential briefing occurs every day at the White House, the press secretary or assistant or deputy press secretary steps up to the podium and speaks, and they are absolutely speaking on behalf of the president. I mean, that is their job, because the president does not have time to do daily gaggles with the press. He or she hires someone onto their staff to do that for them. And so for the press secretary to say, these are my opinions, these are not the opinions of President Trump or President Biden or President whoever, it's demonstrably false.
Okay, fair. It goes on to say, I understand and agree that this declaration is a religious commitment about spiritual awareness, Scientology religion, creating a better world. I further understand that all church members are they have to serve in pursuant to their religious organizations and are not in contemplation of receiving any compensation whatsoever, and in doing so, they're forsaking all commercial and financial motivation. That's a mouthful.
Yeah, what they're attempting to argue here is, if we don't have the money to pay you, or we choose not to pay you, you can't say that you didn't get paid by signing this. You know that you are not expecting compensation, but rather you're doing this for the greater good of the church and not for the better, not for the individual fulfillment of you individually.
Right. Each considers him or herself a volunteer to create a better world, and understand that he or she is not an employee, is not entitled to receive secular benefits such as minimum wage or overtime compensation. We kind of talked about that a second ago, didn't we?
Yeah. That's going to be hard to hold up to a good challenge.
It seems to me like this contract is because contracts have to be fair, right? They have to be for both the person, the organization, and the person signing it. It seems to me this contract is very geared toward protecting the church and not benefiting the person signing it. What are your thoughts on that?
I don't necessarily want to say that a contract has to be fair. What I would say is a contract has to be equitable. Equitable does not mean equal.
Right.
Right. It's kind of like saying, oh, well, the wife got 51%. She didn't get 50%, or the husband got 57%, and the wife only got 43%. Equitable does not mean equal. And as long as it is not so one-sided so as to, basically render the person helpless, generally speaking, people are entitled to contract into whatever they want to. I could go down the street right now to a predatory payday lender that charges me 1,000% interest on a $100 loan. And is that contract one-sided against me? Absolutely. But I entered into it willfully and knowingly. And so, right, I mean, the fact that I made a really bad financial decision should not be the problem of the payday lender.
Even if the person signing this is the age of like 14 and, by the age of 19 didn't change didn't go back, and they may not have realized that they had the option until the age of 19 to go back on it, for example. They are then locked in from that point onwards.
So that's a little bit different, but that's why we have the 1 year cushion from the time you reach the age of majority, which in the U.S. is 18. From the time you become an adult, you have until the time you become an adult to the time you turn 19 to figure your life out, which is a little bit asinine, because the closer to 19 we get, the more off the rails our life tends to get until we get to about 24.
Exactly.
Statistically, but that's what the law provides.
Yeah, precisely. Okay. I mean, this just goes on and on with very similar things. It's saying that we're a religious order, we're volunteering for a better world. I acknowledge that this declaration binds me to follow the ecclesiastical, moral, and ethical policies, rules, norms, and practices of Scientology religious philosophy as a member of a religious order, and to follow administrative policies and procedures of the church. To me, that just says, yeah, I'll follow the rules, right?
Essentially, yeah. It's all about putting them on notice. They can't come back later and say, I didn't know. That's all they're trying to do, is stop somebody from coming back later and saying they didn't know.
Okay. And then this sounds like an NDA kind of non-disclosure clause, right? I agree to maintain the confidentiality of all communications, all documents and files, all mailing lists, and so on.
That's exactly what it is.
Yeah. In other words, that leaves blah, blah, blah. Okay, fair. Upon conclusion of my service as a staff member, I agree to return all materials. I think that's pretty standard in the contract of employment. I agree that any claim, dispute, or controversy arising out of this declaration and application, or relating to any Scientology or Dianetics services, shall first be submitted in writing to the International Justice Chief, who shall decide the matter in accordance with the religious doctrines of the Church of Scientology justice procedure. I understand that in the event I'm unhappy with the decision of the IJC, that I may have recourse to other ecclesiastical justice procedures described in the policy of the Church. In no event shall any such claim or controversy be submitted to a court for judicial determination, as the parties understand that such matters are religious in nature. Now, this is the big clause that is debated so much about, saying, no, you have to subject yourself to religious arbitration, right?
Well, what it says, it doesn't, this isn't, this is the arbitration clause may be, a couple of different things, but it may exist in a couple of different paragraphs, because this just basically says you're waiving your right to seek recourse in the district court. Although it says the IJC shall decide the matter, and if I don't like it, there's other avenues available. I would argue that if I'm signing this contract, I need to know what I'm entitled to know what those other avenues are prior to signing this. And if they're unwilling or unable to produce it, then this clause would arguably be subject to getting tossed out, because I didn't have a reasonable opportunity to research that clause and the effect of that clause prior to execution of the contract.
And is it legal or right for a contract to literally state, in no event shall I ever take anything to do with Scientology to the courts? It will all be handled internally. Is that actually enforceable?
Yeah, that's super common, even in the States. If you ever get into a dispute with AT&T or Verizon or any of the cell phone providers, cell phone service providers here in the States, there's a clause that every time you sign your contract to enter into a contract with them, if you get upset with them and you are dissatisfied, you give up your right to sue them in district court, and you agree to go to a binding arbitration.
Wow. And that's completely okay and legal to do.
Yeah, as long as you are aware that you're giving up your right prior to signing it, which is why they put it in front of you and say, all right, read and sign. Let me know if you have any questions. Nobody ever reads it. They go to the bottom, because the first thing they do is they say, sign here. Well, you have the right to read it. And so, my wife, anytime we go anywhere and they hand her a legal document, she'll tell them, pull up a chair. It's going to be a while, because I read every word of it. I ask questions. And I say, yeah, we're not going to do this. Hey, either change this language, or we're going to stand up and walk out of here right now. It's your choice. And I read everything. Just out of habit. I mean, I've even, when I update the software on the computer, I even read the end user license agreement and the privacy policy that's hundreds of pages long. It takes me a couple of days, but I do read them.
Wow.
And nobody ever does that, right? You turn on the phone, you hit accept, and you move on to the next screen. Nobody ever reads what you put in front of them, but that's sort of a buyer beware thing.
We should do a whole stream on that, because I'd be fascinated to dissect some of those privacy policies and things with you at some point. That's a whole nother video. The next bit here, I mean, we can kind of gloss over this, because this is just basically saying that this is our holiday allowance, our sick leave and pay, and we're not going to pay you. You might get weekly pocket money, which we kind of covered before, right?
Right. I think Aaron says his was supposed to be $50. He didn't get it much. I think yours was 20 pounds. I think it's the discretion of the org.
Yeah, our pay was dependent on the amount the org made the week before. So if we made a buttload of money on the Friday, we'll get paid more. And if we make no money, then we'll get no pay. It averaged out to be about £20. Sometimes I got 200 quid in a week. Sometimes I got nothing. It just depended on how much money the org made. It wasn't an expectation.
So just for my benefit, is quid roughly equivalent to £1 sterling?
Quid is a pound. Yeah, it's just another way of saying £1. Okay. Yeah, so $1.50 or whatever it is.
Well, so for here we have like $1 and a buck.
Yes.
Right?
Yeah, exactly.
Okay.
Yeah,
I hear it all the time, and it seems to be a 1-to-1 ratio. So I just assume quid was street slang for pound sterling.
It is. Yeah, you're completely right. It's like buck and dollar. You're right. Yeah. Okay, and then policy. I mean, that's already been said again. It seems like repeating itself, right? It's the staff is subject to existing policy. You have to study and examine your knowledge on the policies, and you may be dismissed in accordance to policy, right?
Mm-hmm.
Breach of covenant. If a staff member who receives services for no cost and up to 50% breaks his agreement, this is basically saying, if I leave my staff contract prior to the length of service that I agreed to, I will pay back all of the value of all of the services I receive for free during my time as a staff member.
Yeah, this is the excuse me. This is the freeloader clause.
Yes.
Now, people leave all the time and have, hundreds of $1,000s in freeloader debt. The church is never going to come after them because they don't want to file a lawsuit. The only way to foreclose on that freeloader debt is to file a lawsuit.
Sure. And they're just not going to do that. And
No.
if they did do that, would that open up this whole contract to
Sure.
litigation or
Just
discussion in the
yep.
court, right?
It would be discoverable. There would be portions, lots of, maybe the entirety of it would be argued. And I mean, there'd be thousands of pages of briefing. There'd be hours of argument, hundreds of pages of transcript. Yeah, absolutely. It's a freeloader debt. I think Aaron left with freeloader debt. Mark and Claire may have left with freeloader debt. Ultimately, it doesn't matter. They're not going to come after it anyway. They technically can, but they can't. They can contractually, but they can't afford to from a practical perspective.
My freeloader debt was a negative. They owe me money.
Yeah, which they're not going to pay.
No, of course not.
No, they're not going to pay you for that.
All right, and then we have ethical conduct. As a member of religious order, you're expected to uphold a high degree of personal ethical standards. Thoughts on that?
It's just it's a standard release clause.
Yeah.
Because the problem is, I mean, I can agree to be ethical, but one's ethos and moros can vary. What's ethical in the States is not necessarily ethical in Europe. For example, it's generally considered bad taste to tip wait staff in Europe, because in Europe you pay them a living wage. Here in the U.S., tip wage is, I think, $2.35 or $2.30 an hour. And then they expect the customer to make up the fact that they're tightwads and don't want to spend money on their employees by tipping. And the reality is, if you come and eat at a restaurant in the United States, if you're not prepared to tip 20%, you shouldn't go to a restaurant.
Sure.
Right. So in Europe, that's really, that's unethical of the employer to not pay their employee a living wage. But the law allows it. So what's legal isn't always ethical, and certainly isn't always moral. And that's one of the battles that the law has. The law can't keep up with morality. Medical science has advanced to the point that the law can't always keep up with. Just because it's medically possible, does that inherently mean that it's also ethically or morally proper? Just because it's physically possible, the law struggles sometimes to keep up with those sorts of things.
Okay. Entirety of the covenant. The church shall not be obliged to honor any verbal promises or any other terms or conditions not specifically covered in this covenant. The covenant forms the entirety of the church's agreement with the church staff member and promises no specific counseling, training, posts, or any other such benefits to staff member. I find that fascinating, because this is one of many agreements you have to sign in order to join staff. What are your thoughts?
So I refer to this as the four corners clause. It basically says, if it's not within the four corners of this document, meaning the stack of pages that make up this contract, if the words are not in here, the right doesn't exist. The privilege doesn't exist. The protection doesn't exist. And essentially, you're limited by whatever words are contained in this document. If the document doesn't have the words, you don't have the right. It's that simple.
So what does that mean for the fact that there are several documents that you have to sign that all contain this clause? Which one is the one to go by?
So it would be fact specific. If this is the general release that everybody has to sign, then as it pertains to your general employment or status within the church, this would govern. And then if you have to sign a separate one that's specific to your position or your occupation, then, if it's an occupational based query or question, then, but it's a great question, and different courts handle it differently. But essentially, if the risk you run with all of these contracts is you run a risk of provisions becoming, counter to one another, right? Contradictory. And it creates a problem, because contradictory provisions, you cannot enforce one, because by virtue of enforcing one, you inherently violate another. And generally speaking, if we challenge it, we bring all the contracts to the judge and say, judge, figure it out. If we find conflicting provisions, the judge is generally going to throw out both provision A and provision B. So then you're left with sort of that vacuum. And does the contract allow that? Is there enough material left in the contract to fill that vacuum, which goes back to what we talked about earlier, with a sufficient number of sufficiently definite terms?
Fascinating. Okay. Clause 10 is association with individuals not in good standing, basically saying I won't associate myself with enemies of the church. I think that's a pretty expected clause, and there's nothing outrageous about that, or am I wrong?
No. So in the U.S., the courts would generally not get into the weeds of interpreting this, because this is starting to approach dogma, church policy. Right. Courts are not in the business of being religious scholars or theologians. And so as long as the clause itself doesn't run afoul of any statute, you're generally okay.
So why would they need to put this in a contract if it would never be debated in a court of law?
Because this allows them to handle people who associate with SPs internally.
So it gives them, it scares the person signing the contract into thinking this is a,
Well,
we legally have something to hold over you because you signed it, right?
Well, it doesn't just scare them. Like, they're not going to take them to court, but if a person associates with an SP and then they try to and the church decides to declare them, they don't really have much argument, because the church is going to say, we told you if you associate with an SP, you're out of here.
Mm.
You can't say you didn't know. Oh, well, the fact that you didn't read it isn't our problem. The fact that we never let you actually read it, we held it in our hands, and while you signed on the blank line, well, that's inconvenient. You should have asked for it. We would have given it to you. You can never prove that they refused to give you a copy, but
Sure.
it's a different argument.
What does this statement here under general release mean? It kind of seems like an out of place sentence to me. As consideration for being permitted by the church to become a member in a Scientology religious order and become an active participant as a staff member within the church as provided in this application declaration and general release.
So the reason you're confused is because you're seeing the phrase as consideration, but it doesn't mean what you think it means.
Okay.
Consideration is a legal term.
Right.
Consideration. So in order to have a contract, you have to have an offer, you have to have an acceptance of that offer, you have to have consideration, and you have to have performance. And in order to have a lawsuit sounding in contract, you also have to have a breach of one or more of those elements. Consideration is defined as bargain for exchange. And so that, which again, doesn't mean anything in a vacuum. So it is either agreeing to do something that you're not otherwise legally required to do, or agreeing to refuse, or agreeing to refrain from doing something you are otherwise lawfully allowed to do. The classic case on this is there's a 19-year-old boy, and his uncle makes a promise that says, if between now and your 32nd birthday, you don't drink, you don't smoke, you don't do drugs, you don't gamble, and you don't engage with women of the night, I'll give you $50,000. So on his 32nd birthday or whatever, the uncle had long since passed away, and he knocks on the cousin's door and says, hey, your uncle owes me, your dad owes me 50 grand, and here's all the evidence that I followed the contract. And they said, we don't want to pay you. He wasn't serious about it. Well, they went to court, and the judge said, at the age of 19, at that time in the country, you could gamble, you could smoke, drugs were not illegal. Spending time with women of the night was not, paying them for their services was not illegal. These were all things that he lawfully could have done, but he gave up his right to do that in exchange for the opportunity to receive $50 if he refused to engage in these activities. So it's the same thing as the bargain for exchange. So what that says is, the consideration is, you are not legally required to let me join as staff, but in exchange for letting me join as staff, I agree that whatever the rest of the provisions are.
Interesting. Okay.
Right. So in essentially, by virtue of you allowing me to join staff, which you're not otherwise legally required to do, I agree to be bound by the terms of this document that I just signed, which I normally would not be limited in my behavior and what I can do within the limits of this document, except, right, that's the bargain for exchange. You're agreeing to do something you're not legally required to do, and I'm agreeing to forego certain things that I'm otherwise legally allowed to do. Normally, I can spend time with whoever I want to. I can seek mental health treatment. I can consume alcohol. I don't have to be an ethical person. I just can't be an illegal person, right? And so that's generally the concept there. So the reason you're confused by it is because the as consideration for being permitted, the term consideration doesn't really fit that sentence, because it's not being used in the layman's context. It's being used as, in the legal context, as one of the elements for contract.
Fascinating. Okay. And then I think, because I know you've got to go in a few minutes, we'll get to the bottom of this one and then call it quits if you want, because I know you've got a bit of time pressure, and we can kind of revisit the rest of them after. Maybe on another stream. It says, I hear but this one here basically says, I'm not going to sue L. Ron Hubbard, the RTC Religious Technology Center, Church of Scientology International, any organization. Again, it's a repetition of the clause we saw earlier, but it's being more specific about who exactly I agree not to sue, right?
Correct. Okay.
And there's nothing untoward about that. That's totally normal and legal and fine to put in a contract.
Yeah, it's essentially the church is limiting their liability, and you're agreeing to limit it, right? And so what I mean by that is, if you go to an amusement park, on the back of the ticket it says, by virtue of walking in the door to the amusement park, you agree that there are certain, if you get hurt, you're not going to sue us. There are exceptions to that. Essentially, it's the inherently dangerous. Like if I die in a skydiving accident because my parachute didn't deploy, that's an inherent risk of parachuting, of skydiving. If I die in a skydiving because two airplanes collided, that's a different issue, right? That's not an inherent risk. Or that I slipped and fell on water that was on the ground and I broke my ankle or broke my hip. That's something that's not an inherent risk of skydiving. An inherent risk of skydiving is my parachute doesn't open or the airplane catches on fire or something like that. So
Sure.
that's sort of that's sort of the context that it's based in.
And is it okay? Because, for example, in the UK, Scientology operates through this Australian registered charity we talked about previously, but that isn't, as far as I'm aware, owned or associated with the Church of Scientology International, the US-based ones. So it seems a bit strange to me to have in my employment contract, I won't sue these other related but not actually kind of, formally associated organizations. That seems a bit odd to me.
It's tangential.
Mm.
I could talk about that for hours, but it's a little bit nuanced, but it's not as, it seems weird because we don't have any context for it, but it's a little more common than perhaps people think. The world we live in is governed by contracts. I mean, the people who repair the potholes on the road have contracted with the government to repair that pothole. And if they don't repair the pothole correctly and you tear your car up or get injured or something as a result of driving through that pothole, I live in a part of the country where we have potholes the size of like school buses.
Right.
So, that's sort of the joke. You go south into Texas and sometimes the roads get better, sometimes they don't. But, there's certain things that you can't, in certain capacities, you can't sue the government. In certain capacities, you can. It's called the Government Tort Claims Act, and states have a version of that, but it's sort of the same, I guess.
I kind of see that as going like, you won't contract with the government and saying, not just you won't sue us, but you also won't sue the government of France.
Yeah.
Because they're related, but not, if you get what I mean.
So let's say I enter into a contract with Coca-Cola, and at some point down the line, or no, with some mom and pop cola maker, beverage maker, and at some point they merge with Coca-Cola. Coca-Cola buys them. Well, the way that liability limit reads, I can't now sue Coca-Cola. Oh, well, mom and pop don't own it anymore. Now I can sue Coca-Cola. No, Coca-Cola assumed the contractual provisions of that company when they took it over. And even if they didn't, right? Because the deal is, people say, well, if I don't sign the contract, I don't get the job. That's true, but that's capitalism. If you can't agree on the terms of the job, don't take the job. If you're willing to agree to the terms, no matter how inconvenient or oppressive those terms might be, because you need the money, that's your right. That's also the business's right to limit their liability. No business would ever engage in commerce with anybody else if their ability to get sued was just, unlimited and existed forever for the rest of history. There would be no business conducted in the country. Okay.
All right, fair enough. Makes sense. Last couple of points here. I hereby release and discharge the releases from all actions, claims, and demand. This is, again, just another clause saying I won't sue them, right, for injury or damage.
Anytime you see hereby release and discharge, that's, even C, I further agree to indemnify and save and hold harmless the releases of releases or releases from any law. Yeah, it's the same thing. It's just repetitive language over and over and over and over again. Lawyers get paid by the word. Sometimes we get paid by the page. We get paid by the hour, by our time. So the more words we can put in there, the more phrases we can put in, the more money we can make.
I think also it's kind of a tactic of scaring people and making them believe, this is a legal document and it's serious, it's official because of all these words you don't understand. Let's confuse these people into signing it and they'll just go, okay, fine, whatever, rather than genuinely debating and considering every single point, because you just get lost in all the terms, right?
Yeah, exactly.
Yeah. And then the document concludes just with this sort of, I've carefully read it. I'm aware this is a release of liability covenant not to sue, and so on. It's recapping. And you sign here and you attest to being not being under duress. It's of your own free will. And I believe and agree in Scientology, and I'm not doing it for monetary gain, or I'm not doing it in return for free training. And that's the end of the first general release. Do you have any thoughts from looking at this one in as a whole?
Yeah, other than those few things we pointed out that would probably, if challenged, be kicked out, for the most part, it's a pretty standard agreement. Now, if you look right underneath signature of applicant and you slide to the left to the next line, signature of parent or guardian if a minor. So this does have. Now, yours may not have, and this may have been a change they made since you signed yours, but
I'm pretty sure mine had this, but it was certainly never signed by my parent or guardian.
Yeah, and that would be, if at some point prior, at least in the States, prior to your 19th birthday, you decide to challenge it, if your parents never signed it, they're not. When the parties are contractually bound, we call that being privy to the contract. And when they're in a contractual relationship, they have privity of contract. If your parent never signed it, they do not have privity of contract with the church, so they are not bound. You are not, you nor they are bound by this contract if you decide to challenge it on the grounds of voidability due to the age of the person at the time of the signing.
Okay, all right, fair enough. Well, look, let's just quickly wrap up here, because just to give people an idea, this is the first and the biggest, the main kind of contract that you sign when you join staff. There are other ones, like this is an agreement of release on spiritual assistance. Then you have the religious services enrollment application and another general release. You then have, which is a little bit lengthier, then you have the agreement regarding confidential files. You have the attestation regarding, have you watched the film called Orientation? And that's it. That's the whole packet of legal paperwork you had to fill out when you join staff. And I know you've got to go, but let's maybe jump on another stream later this week or something. We can carry on.
And I've got a couple of minutes if we want to grab these super chats that you've got. I want to make sure that if there's a question or an answer that I can provide, let's make sure we get that done.
Okay, great. There's not that many. Obviously, we had this one from Christian B earlier, so thank you for that. Selena's in the chat talking about holiday pay. I think this is when we were saying that, you as an employee in the UK, you have a right to holiday pay and sick pay and things like this. And by signing this contract, even though you're signing those rights away, you are still is a legal entitlement. And I don't believe this contract actually can supersede that right if you are deemed an employee in UK law anyway.
Yeah, and that's the trigger. If deemed an employee, regardless of what the contract says, regardless what your title is, if the courts deem you an employee, then you get those benefits, and you can actually get those benefits after the fact. Like, hey, they should have given you holiday pay for Christmas 10 years ago. They're required to make back pay with interest. So, at least in the States, I can't speak to UK law, but in the States, it's the same way. If deemed an employee, you have recourse going back in time.
Yeah. And I think here, Ewan made a really good point. UK law, pretty sure staff contracts are illegal, but not sure SEALC ones are. Boarding is a big exception to UK minimum wage laws. I think the key thing here is when people talk about the SEALC contract, the staff contract, it's not just that 1 billion year contract that you sign that says, yes, I pledge my life away. Actually, the staff contract is like 6 separate documents that are all their own, like it's a bundle of contracts that all have their own enforceability and clauses and all of this. So there are some clauses in some of them that may be deemed illegal, like, for example, signing 1 billion year contract. That's not going to be upheld in a court of law because that's obviously, a stupid contract. But a contract like the one we just saw that doesn't actually have a time limit in it. It just says, that you're signing this, you agree to these principles. That is more likely to be accepted by a court of law, right?
Right. Yeah, I agree.
Okay, fair. And then the last one, Tina and the last 20. I want a t-shirt with "I am a cult-based employee." I love that. We should do a collab t-shirt, Zach, if you're up for it.
We should. I'll put that on the merch store for those of you who haven't. If you jump over to your Lawyer Friend Zac, like and subscribe, and check out the community page. I'm at as I get to 10,000 subscribers, we're gonna do a 10,000 sub party. We're gonna have some autographed merch. We're gonna give away some swag. We're gonna have some special guests come on the channel. So, if they haven't already, hop over there. Make sure you like and subscribe to that as well. But yeah, if we can come up with a collab T-shirt, I'll definitely put that on the merch store.
Yeah, I love it. I've just put a link to your channel in the live chat. I'll design something and send it to you, and we'll put that up on our stores soon. And we'll have to do another stream later this week and carry on with this.
Absolutely.
For those of you watching, I am going to be live again in an hour or two at 10 o'clock UK time, which is 5 p.m. Eastern. I'm going to continue the discussion with Jeff Beaumont, who was a former Scientologist Sea Org member over in Canada that was trafficked as a child from Canada to the US. Kidnapped and trafficked to work for the church. He did a lot of activism work for the anti-psychiatry kind of drug-free marshals program Scientology have. So stay tuned for that. We'll be back in a couple of hours. Zac, thank you so much for doing this with me. I love having you on. We've had a really good engagement from everyone. And yeah, any final thoughts?
No, I think it went well. We'll jump on and we'll get through the rest of those contracts hopefully the next days or weeks. And guys, as soon as Alex gets done with his chat, if you'll hop over, I think at 8:30 Central, so 9:30 Eastern, we're gonna do a Monday night holiday special. So come on over, hang out with us for a while.
Go and check out Zac's channel. Do it. Go give him a like and a subscribe and all of that. And Zac, thank you so much. We'll catch you soon.
Sounds good.